Talked last night. He's on leave. This is a service she's in so she's physically in the city. She works with them. All right, well, good morning, everybody. Thank you for coming. Thank you for attending this roundtable on regulation by litigation, sponsored by the Center for Business Law and Regulation here at Western Reserve University School of Law. First, just a couple initial things. Wanted to thank Nancy and us for all the work that they put into logistically for making this event possible. Also, thank Murray and the Cook Foundation for supporting this program. Part of the origins, kind of two origins of this program. One is Center for Business Law and Regulation is interested in programs that try and go deeper than the standard academic panel where people just show up and talk and maybe you have a video but just to engage in more deeper discussion of recent scholarship, issues relating to regulatory law and policy. And so we're hoping that this event is the first of what will be many roundtable colloquia on recent scholarship relating to regulatory policy. This book has its roots, or 2/3 of its roots at Case Western, as Andy is still on our faculty. I like to say when most of his portions of the book were written. So this is also part of our way of reminding folks that if you like the book or if you hate the book, the blame or the credit, or at least part of the blame or credit, belongs here. Initially, I was going to ask everyone to go around the room and very briefly introduce themselves, because I'm not sure everyone has had the chance to meet, and then I will explain how we will proceed. So, I'm Jonathan Adler. I think I've met virtually all of you, and I'm director of the Center for Business Law and Regulation, and I teach here at Case Western.
I'm Bill Funk. I teach at Lewis and Clark Law School in Portland, Oregon, and I write and teach in the administrative law area as my center, and then environmental law and constitutional law as the practice and theory part.
I'm Jonathan Enton. I'm the academic dean here. I'm a common law and administrative law person.
Hi, I'm Jackie Lipton. I'm the Faculty Development Dean here at Case, and I write and teach in the IP and cyber law areas.
Eric Chafee. I'm a professor at University of Dayton, and I teach in the business and securities law areas.
I'm Yuri Lenetsky. I teach here at Case, primarily in our civil litigation clinic. And while in private practice, I had a chance to litigate both sides of asbestos cases.
I'm Cassandra Robertson. I teach here at Case Western, and I write and teach in civil procedure and professional responsibility.
James Wycamp. I'm a research fellow for the Center for Business Law and Regulation and 09 graduate of the school.
Bill Jordan. I'm the associate dean at the University of Akron Law School, and like Bill, Bill. My main field is administrative law, environmental law.
Mike Creed, AEI, constitutional law, business education.
Catherine LaCroix, I was an environmental lawyer for Coleman Hardson in Washington, and now I live here and I teach at KISS.
Jack Bierman, Boston University, my fields are administrative law and civil rights litigation.
Andy Dorchuk, I work at the Law Library at KISS.
Eddie Morris, I teach at the University of Illinois. Bruce Yandel, Professor of Economics Emeritus, Clemson University.
I'm Kalyani Robbins. I teach at the University of Akron School of Law, and I focus on environmental and natural resources law, but also teach criminal law.
Heidi Robertson. I'm a professor and associate dean for faculty development at Cleveland Marshall at Cleveland State, just down the road. And I teach environmental law and property.
Dennis Hirsch. I teach at Capital University Law School. My two areas are environmental law and information privacy law.
Jim Blumstein, Vanderbilt Law School, constitutional law, and health law and policy.
Ken Kilber from the University of Toledo College of Law, where I focus primarily on environmental and administrative law.
I'm Susan Bentley. I'm the director of the Regulatory Studies Center at George Washington University and teaching the policy school.
Karen Harned. I'm executive director of the Small Business Legal Center, which is affiliated with the National Federation of Independent Business, and we do a lot of regulatory litigation.
Ryan Mannix. Most recently I was running the policy office at EPA, was well steeped in regulation and litigation. I'm an economic consultant.
Marty Poydar, I'm the legal associate at the Code Foundation.
I'm Dale Nance. I'm a member of the faculty here. I teach primarily in basic and advanced evidence courses.
I'm Gary Colonisi. I'm at the University of Pennsylvania Law School, where among other things I teach environmental law and administrative law.
I'm John Cannon. I teach environmental law and land use law at the University of Virginia School of Law.
Great. The way we're going to proceed is one of our authors, I think Bruce, is going to open up and do some opening remarks for about 10 or 12 minutes. Then we will hear from Bill, John, and Carrie. It's John, Bill, and Carrie in terms of their reactions to the book. Andy is going to respond. I think then we will take a very brief caffeine break and then come back for open discussion on the book, the themes that it raised and that were raised by the comments and other things related to the subject. So without any further ado, I will turn it over to Bruce.
Thank you very much, Jonathan. We thank you and the Center for organizing this event. I'm speaking for my two colleagues in Hill and making the remarks. And thank you to BP for being here. There's a huge amount of talent and knowledge in the room, and so the prospects of our getting an improvement on ideas about regulation by litigation are large, I would suggest. Writing in the American Prospect in 1999, Robert Wright, Secretary of Labor in the Clinton administration and now Professor of Policy at UC Berkeley, announced that regulation is out, litigation is in. The era of big government may be over, but the era of regulation through litigation has just begun. What on earth was he thinking about? What set of facts might have prompted Wright to make such a forecast about the behavior of the federal government in achieving regulatory goals? At the time his opinion piece was published, the state attorneys general in 46 states had signed a $246 billion settlement with the tobacco industry that specified, among other things, how they would market their product. The terms of the settlement now form part of that industry's regulatory environment. This was not all that he observed. The major producers of heavy-duty diesel engines had signed a $1 billion settlement with EPA that specifies how and when the industry would regulate nitrogen oxide emissions. Added to the list were EPA suits involving new source review against the wood products industry, the paper industry, major components of the petroleum refining industry, and 10 large electrical utilities that generated electricity primarily from coal-fired plants. There were also suits against gun manufacturers orchestrated and coordinated by U.S. Housing and Urban Development. The end purpose being to require the manufacturers to put safety devices locked on guns. The suits that I mentioned were about definition or redefinition of command and control regulation, among other things. And so a regulation by litigation became the subject or topic of conferences, symposia, and several books. Yet like most complex social phenomena, it is far from clear to me, and sure to us, what triggered this new form of regulation and what the implications may be if and when it displaces other regulatory and legislative processes. We need to be clear at the outset, as we attempt to be in our writing, what we're talking about. That is, we're speaking, broadly speaking, we're talking about litigation by a regulatory agency that has the authority to regulate in the first place, that involves all or most of the firms in an industry or a subpart of the industry, where the result of the litigation is a settlement that contains forward-looking command and control regulation affecting each of the settlement parties. Put differently, we're talking about regulatory outcomes that could not readily be distinguished from the outcomes obtained through a notice and comment rulemaking procedure. That is, it would look an awful lot like a page in the Federal Register in terms of the regulatory outcomes. Now, our cases and what we're talking about, of course, goes beyond that. But in a sense, that's the narrow focus as we introduce this topic. Our work began in 2001 when we became engaged in a research project that had to do with the diesel engine story that I've just mentioned to you. And that case, as mentioned, involved a suit brought by EPA against all the producers of heavy-duty diesel engines, the ones used principally to power the big trucks that we dodge on the interstates. And it's critical to note in the story, as I think we do, that the engines were already regulated intensively and historically by EPA. And so, as we see it, it's not a simple enforcement action. And indeed, the agency could have theoretically devised a remedy by way of traditional notice and comment rulemaking. But instead, the case, based on existing rules, alleged that the producers had gained EPA's emission control rules by developing controllers that varied the levels of emissions depending on where the trucks were operating, thus increasing emissions in the open country and reducing them in urban areas. And since EPA had trumps in terms of issuing permits for engines to be sold in any particular year, as we saw it, the industry was not reluctant to settle to terms specified by EPA with respect to emission controls and future designs of engines. And so EPA imposed a set of new forward-looking regulatory standards on the industry through regulation. The suit was brought in 1998. Now, in our book, we review theories of regulation that have evolved to shed light on regulatory processes and regulatory behavior. We describe what we call the regulator's dilemma, that is the dilemma of choice as to will I regulate or not. Part of that dilemma has to do with the question, well, what are the net benefits of taking a very costly action? That is, assuming that the regulator is pursuing the public interest. What will be the net benefits of my action when I engage in this incredibly costly process? And having answered the question, yes, I think there are net benefits, then the second question is, how will I regulate? What means will I use? What choice will I make? Now, as we talk about these theories, in a sense we are asking the reader to rise above the details and the dust and the action out in the real world in a very highly stylized way, to think about a person, a regulator, a human being making a choice. And we realize that is stylized because sometimes it's awfully hard to find the person at EPA or the Federal Trade Commission or at Case Western University who learns and now knows and acts. But as human beings, we use that highly stylized language to describe decision-making processes. And so I ask you to think about this hypothetical regulator who's a human being. And this human being decides whether, when, and how to regulate. We can picture this person with a set of facts on a table as he or she contemplates a decision. Having decided to act, the regulator has 3 buttons that can be pushed. One says, regulate by notice and comment rulemaking.
Another says regulate by negotiation. A third says regulate by litigation. And we ask, what explains the choice? Assuming that there are human beings making choices, what explains the choice? With respect to the diesel engine story, the question is, why regulate by litigation in 1998 against the industry? There are two parts to the question. Why regulate by litigation, and why 1998? As we sorted through the story, we found a very interesting year 2000 U.S. House of Representatives Commerce Committee report titled Asleep at the Wheel. They were accusing EPA of being asleep at the wheel. And there were multiple instances documented in the report in 1991 and 1993 when EPA personnel were alerted to the fact that there were potential problems with the controllers on these diesel engines. So that's there in the story. That the controllers were being used to defeat the purpose of the EPA regulation. 1991, 1993. And so then the question becomes, why did they wait 7 years to bring an action? Well, part of the answer might be, well, you made the mistake of, that is in the sense of some misplaced concreteness, speaking about this one person who makes a decision, and now you're assuming this one person got the information, and that's on my table, and I will use that information in making my decision. That is, we're talking about a vast organization with lots of pieces out there. And did the information really make it to, quote, the decision? Nonetheless, this report from the Commerce Committee was saying, you guys were asleep at the wheel. Why did you wait this many years to bring an action? And in our story, we attempt to explain why regulation by litigation in 1998, because we have to speak to both parts of the question. First, in 1991, 92, 93, on into 1996, EPA didn't need nitrogen oxide emission reductions. The methods being used for estimating air quality, which is based on some simulation of air quality, was giving readings that said, in a sense, we're making progress. We don't have a huge amount of trouble. We're not getting worse. There are non-attainment regions in the United States, but we're holding our own. We are not at risk in having to define another set of major metropolitan areas as non-attainment with all the horrendous conditions that go with it. We're okay. We don't need it. But then they learned that their estimating procedure had not worked accurately. It's when they measured emissions on the ground and looked at the hard data, they didn't match the simulation. And lo and behold, it was bad. So in 1997-98, EPA needed NOx reductions. And then the question is, where will we get them in a hurry? Because if we don't get them, by law, we will have to define these areas not in attainment as not attainment areas, and that's going to require inspection procedures for automobiles and no major sources of nitrogen oxide emissions, and so on and so forth. A draconian set of conditions. And in the past, EPA had worried about whether they could hold their own against Congress in enforcing the conditions of the Act, particularly against these northeastern cities and states, which would be involved in this particular situation. So they needed those reductions. Well, you could get them from stationary sources. You could get them from automobiles. You could get them from trucks. And so then there gets to be a question in terms of bootleggers and Baptists and special interest regulators. Where will it be least costly and perhaps the easiest for us to obtain quickly large reduction in NOx? Do we want to go after all the drivers in the northeastern states? Or do we want to do what the Yale Center for Environmental Law is thinking about doing, bringing common law suits against everybody who has a license plate? And bringing forced action to reduce emissions. And so, as we know from the story, the decision was made to go after the trucks. They were a better target than the stationary sources in terms of payoff of NOx emission reductions. And much better than all those automobiles. They got a quick fix. The agency, in addition to that, needed an important victory to encourage the environmental community and Regulation by litigation avoided OMB oversight, so we can throw that in as perhaps part of the story. So the regulation by litigation button is pushed. Now, our explanation of the logic of choice turns on constraints. As in addition to the constraints I mentioned, the primary one being we need NOx emission reductions. Another constraint was Congress. Congress had set down rules and guidelines which prohibited EPA from moving in a particular sequence of time in redefining emission standards for engine. That is, give the industry a break, set the rules, 4 years later you can revisit, set new rules, but give them time to internalize the rules. And so they were constrained there in terms of opening up for comment for rulemaking in a traditional sense. And so those constraints were there. The NOx constraint begins to tighten, and then you must decide what part of the NOx producers will we go after. And as we see it, the truckers came up as being the high player. And so our story then turns on theories of regulation, and an assumption that there's a human being making a decision in the face of all that. Now, the broader story in the book, we wanted to explain what was going on in a broader sense. What were the regulatory choices available to these regulators? What were the challenges they were facing? Why was regulation by litigation emerging as the apparently preferred way to accomplish a regulatory end in preference to these other devices? And I should interject here, as we think about this, are we talking about something that will end up being an outlier in the history of regulation as we look back at this century? Or was it just some strange alignment of planets at a particular time that caused this large outcropping of regulation by litigation? In another way, is the world just crazy and we shouldn't try to impose on it any kind of logic and theories in terms of what explains the behavior? It's just kind of random out there, and every now and then something strange happens. And that may not be a scientific explanation, but that's the way we explain a lot of things about the world in which we live. And so then there's the question about welfare for human beings living under a constitution. That is, at the margin, when we act in this way, are there net benefits? And are those benefits larger than would be the case if we proceeded in another way? And so we provide 3 very different cases to illustrate that regulation by litigation goes beyond the more narrow regulatory processes in terms of trucks. Then we get into tobacco, and then into abrasive dust. Now, Robert Reich's story, his comments, his forecast may have been an accurate one, but may not have been. That is, we've got the events. In a sense, do we have a trend? Do we have observations, and observations through time? Or will this continue? That's an open question. Time will tell. And while he was making the forecast, something that he could not have predicted, I don't think, as wise as he is, he could not and did not predict the rise of the super litigator. The super litigator that emerges in the context of regulation by litigation. The super shop that develops a new technology. In Clayton Christensen's terminology, he's a business professor at MIT, he refers to innovators and inventors as coming up with disruptive technologies. Disruptive technologies that disturb the equilibrium of the existing industry and how it operates. And so the super litigators are disruptive in the new technologies they bring to bear. And so that becomes an industry in itself. What did we learn? I guess as we conclude and thought about these different processes and stories, perhaps the thing that came to the forefront of our mind, the concern, had to do with loss of due process. And a second concern related to that was who's keeping score? Who's keeping score? And who is requiring accountability with respect to the alternate ways? Even if you regulate by litigation, there are different ways to write those rules so that you might be able to generate the same outcome at lower cost with all parties taken together. And so now let me conclude in a way with the last words and the conclusion of our book. We do not claim to have found the solution. I think perhaps the better analogy is that we are operating in a huge warehouse of life, and it's very dark. And maybe we turned on a 40-watt bulb over in a corner. That would be our claim, that we think we shed some light on what is going on. Now, some of you might say, I wish you'd turn it off. Close the book. But in our last words in the book, we raised the hope that if nothing else, the book will engender a conversation that will help us have a better understanding about what is going on with regulation by litigation. And so thank you for coming to the conversation.
John, over to you. Okay, thank you, and thanks for the book. I like the book. Do I get to say whether I like the book or not? This is like a report, right? I like the book. I think they use the public choice theory to try to illuminate complex events. It's engaging. I think it's useful. My comments will indicate that ultimately I think it's not determinative of how we inevitably must see these events, but it certainly sheds light on them. And I also appreciate the thoroughness and the care with which the book was assembled and the stories are told. That's useful. It's a useful, factual background on which to engage in discussions like this, and without that careful research, we don't have that. So I think it's great that you turned the light on. I don't suggest you turn it off. I think the task is to try to make it shine brighter and broader and truer across these complex situations. My comments are going to focus on the heavy-duty diesel engine litigation, which is the case that Bruce spent most of his time on. And my purpose here is to argue for a different interpretation of the same story. Not necessarily to convince you that my interpretation is the right one and the author's interpretation is the wrong one, but simply to show that there are alternative accounts that I think are equally credible. And then, having done that, to talk about the use of methodologies or theories like public choice theory as applied as a diagnostic tool in situations like this. What can we expect from it? What's the level of indeterminacy that's left, and what can we do perhaps to reduce that level of indeterminacy? So I guess my overall thought here is that we have the heavy-duty diesel engine story in multiple versions. So it's kind of a heavy-duty diesel engine Rashomon. So the authors argue, Bruce laid out the argument I thought very well, that the heavy-duty diesel engine litigation is regulation by litigation, that the purpose or goal of the agency in that litigation was to impose a new set of policies on the manufacturers of these engines, and to do so by avoiding the rulemaking process, which had certain limitations, delays, legal restrictions, and so forth attached to it. I argue that there is a strong case that the heavy-duty diesel engine litigation was what it purported to be on its face, which was an enforcement action taken by EPA to address an alleged violation of standards applicable to these companies. And my argument relies on a distinction between, a strong distinction between policy making and enforcement. It's not that those two functions never intermingle, but at least my argument is that they are distinct and separate. And it also, my argument also rests on a different view of the institutional incentives that were at work in this case. Bruce talked about hypothesizing the agency decision maker who pushed the button and trying to determine what forces were at work on that agency decision maker. I locate the agency decision maker in a certain compartment of the agency and try to discern what the incentives for that decision maker, group of decision makers were, and my analysis of that is different. It comes out differently than the analysis of the authors in the book. And then finally, I attempted to collect some data from the enforcement folks who actually worked on these cases to determine, to the extent that's possible, what actually went on. And all of those pieces, I argue, lead to the conclusion that this is a very mundane, ordinary, unexciting conclusion that the enforcement case was actually an enforcement case rather than an enforcement case or a piece of regulation or a regulatory initiative that was dressed up as an enforcement case. So that the author's version is more interesting and innovative than mine as an intellectual proposition. So let me talk briefly about the distinction between policy making and enforcement. My argument is that enforcement function is basically to vindicate policy that's been made in other settings through rulemakings, permits, and so forth. And that it has three goals related to that overall function. One is to punish violators and deter future violation. The second is to return violators to compliance. And that is often a very complex process because typically, and this was the case in which this was true, typically violators can't come into compliance immediately because of limits on the feasibility of achieving compliance. So there is often built into the settlement of these enforcement actions an extensive set of interim milestones and other measures designed to push compliance along as quickly as possible, and also to limit the adverse environmental effects of the ongoing non-compliance. And then finally, the goals of enforcement include mitigating the environmental harm of the past violations complained of in the action. And my argument here is that the features that Bruce and his companions argue define this litigation as regulation by litigation are also explained and able to be justified against these three enforcement goals. That it is possible to look at the relief that was sought for and achieved in this case as consistent with achieving one or the other of these three goals, including the goal of mitigating the environmental harm, of trying to recapture, if you will, the environmental benefits lost through the alleged violations by bringing forward certain requirements that we might otherwise have applied. And then to talk about incentives, and I think this is really at the heart of this. I think the authors do a great job of hypothesizing a possible incentive, motivation, and purpose behind this litigation based on the need for reduced NOx emissions and particulate matter emissions in order to meet national ambient air quality standards. States are required to develop plans to meet these standards. States therefore have to find reductions that they can claim in their plans in order to have approvable plans, and that with more stringent standards can be a very difficult proposition. And what the authors argue here is that the states were under pressure and putting EPA under pressure to find some politically inexpensive reductions that the states could then use in their planning process, and that heavy-duty diesel engine emissions were one area, an important area of these reductions that EPA could claim and then give to the states basically to respond to some of the pressure they were getting from the states. And I don't disagree that that pressure was there. I don't have any independent way of documenting it, but my argument is that that's not what drove the decision to bring this litigation in all likelihood. And I argue that because of my own sense of the enforcement function within EPA and of the incentives that drive enforcement officials at EPA, which are not linked necessarily to the incentives that are driving the senior policy officials at EPA. You have to understand that EPA is not a single entity with a single will. It's diverse, it's often fragmented in its decision-making processes, and in some cases, including the enforcement cases, functions are walled off effectively in some ways from other functions in order to preserve their independence. And that's the case here. OECA, the enforcement office at EPA, was established in the early 90s as separate from the program offices. That was done to make enforcement stronger, more independent, prevent the kind of influence that might have led to the scenario that the authors hypothesized. And in this case, I think OECA operated, from all I can tell, OECA operated in this independent mode. They figured out something funny was going on with the controllers. They decided it was a bad thing. They developed a case. They sent the case to the Justice Department. The Justice Department said, great case, let's go get the bastards. And they filed their suit in federal court, and negotiations transpired, and a settlement was reached. As far as I can tell, that all happened, the selection and resolution of the case, all happened without direction, implicit or otherwise, from senior policymakers in the agency, including the chief of the Air Office and the administrator herself. Why would they do that? Why would these enforcement people do that? And do it in a way that seemed disruptive, that even seemed to interfere with the ongoing relationship with the program people to these manufacturers. They do that because they're enforcement people. They think like enforcement people. They want what enforcement people want. They want the big case. They want the big scalp on the wall. That's how they get evaluated. That's how they keep their jobs. That's how they get a pat on the back from Congress, or at least often they do. And what they get counted on is being the cop in the donut shop, unless the cop and not the cop on the beat. So my story hypothesizes a different set of incentives for this sub-part of the agency, and it argues that it's this sub-part of the agency that controlled the decisions in these cases, and therefore you can't assume that the litigation was responsive to or designed to fulfill the purpose that you might attribute to the policymakers. So in the end, I say that this is a rich and interesting account that the authors have offered. It helped me think through, again, the way I think the agency operates. I think ultimately it rests on a somewhat simplified view of the enforcement function, and also on conclusions about the motivations of officials and the influence of particular officials or particular classes of officials on decisions that is not necessarily what obtained. I think ultimately, however, the most interesting thing about this account is not whether I'm right or the authors are right, because I don't think we know ultimately. I think the interesting thing is both about the promise and the limits of public choice theory as applied to cases like this, cases that arise in complex institutional settings. Even if you accept the premise of public choice theory, and I have for purposes of my analysis, I think it's often difficult to get a definitive account or a definitive version of what goes on. You can shed light on what goes on, but it's difficult to come to an account that would be beyond dispute, because you have to determine, really, you can hypothesize a sort of an ideal decision maker, but in fact, the decision makers within these agencies are different people in different settings with a different set of incentives. So you have to figure out who really was the influential person and what the particular incentives might have been that affected them, and that is often very difficult to do. So I thank the authors for their contribution. I'm interested in this challenge to try to make more definitive use of very powerful theory, and I'm very sympathetic to the project of trying to do so. Thank you.
Thank you, John.
Bill?
Well, I don't know if I liked the book or not, but I enjoyed reading. Because, as I told the authors, while I'm generally not going to say positive things about it, there is one positive thing about it. It's quite amazing. And it takes a complex subject and makes it understandable without the use of jargon, and tells interesting stories. So it's a good read, right? Almost as good as the spy novel The Plane Coming Here, and almost as truthful. My written comments address all three of the case studies, and John, his written comments really focused on the first one. And it was amazing that we both wrote without having talked to each other, without seeing each other's work, and yet amazingly we came to the same conclusion, in the sense of we weren't convinced by the explanation of the book, and in fact what appeared to us to be independently the correct explanation was this was just standard enforcement work. But I wanted to add one point that John didn't make with respect to the heavy-duty diesel case, and that is, does public choice theory, even accepting the facts as presented by the authors, suggest the outcome that they suggest? The book says that public choice theory explains EPA's actions because, quote, public choice tells us that concentrated benefits and diffused costs are the stock and trade of the successful politician. And then the book characterizes the effects of the heavy-duty diesel litigation as the benefits were concentrated on environmental groups and state regulators. Environmental groups because the environment would improve, state regulators because they would be relieved from having to regulate within their states because now the federal government is doing it instead. Whereas the costs were spread among essentially all consumers, since transportation services affects most products. But is this an accurate portrayal of the situation? First, environmental groups do not benefit from an improved environment or tough EPA action. Indeed, as many have shown, membership in environmental groups and donations to environmental groups go up when EPA does nothing and when the environment gets worse. So actually, in terms of public choice theory, environmental groups do better when everything's getting worse, not when they're getting better. In addition, public choice theory tells us that regulators get rewarded when they increase their power and prestige. Well, state regulators' power and prestige was not increased by having the federal government take away this regulation and making their job irrelevant. So, in that sense, these weren't the beneficiaries. Well, who were the beneficiaries of the regulation? All people who breathe cleaner air. And that's about as diffuse group as you can find. And who were the costs concentrated on? Well, the costs were concentrated on the very small number of engine manufacturers. Sure, this eventually ended up being passed through the economy, but the initial costs were heavily concentrated in a small group. This is exactly the situation where public choice theory would suggest that, indeed, EPA should not have won, but the diesel manufacturer should have won because the concentrated costs outweighed the diffused benefits. So that's the heavy-duty diesel case from my perspective upon public choice theory. In looking at asbestos litigation, as Bruce pointed out, this isn't the sort of paradigm case of federal regulators regulating through litigation, it is litigation. And indeed, it's not regulation at all. Whatever we can say about asbestos litigation, it isn't regulation. It is pure tort action, the transfer of money from one set of people to another. The fact that it resulted in a lot of people going bankrupt and having all sorts of effects that we might not like, it just doesn't rise to what we call regulation. It is simply the transfer of money from one group to another. And whether that was a good thing or a bad thing, I mean, the authors suggest that it was very inefficient. And indeed it was, or is, continues to be. But tort law is inefficient, all right? Whoever said tort law, and I happen to be a devotee of tort law, I like it myself, but the question is, it isn't. Of all the things it is not efficient. It undercompensates many, it overcompensates others, but it's not the tort system at large that authors take on. It's this particular litigation as a subset. I mean, if we wanted to talk about the New Zealand and no-fault system instead of torts, I want to talk about going to a continental model of everybody has to pay the other side's lawyers, no contingency fees. These are all interesting and highly unlikely events in the United States, but that's what we could talk about. But it's not asbestos litigation per se. And how could a regulatory system have attacked the problem of asbestos litigation? That is, what's the alternative to the tort? I mean, it would have been nice if government had regulated asbestos and protected people's health and safety at a time when it might have mattered, but that time was long past and the people were injured. At that point, it's not regulation anymore. It may be a compensation system, right? And the authors talk about workers' compensation as if that's really good. There are those of us who think that workers' comp is itself inefficient and horribly undercompensates people for various reasons. But the idea that this was an administrative system, and here we had the asbestos litigation was judicial, but as the authors point out, what it evolved into was essentially an administrative system. And the fact that Congress, which tried from time to time to come up with its own administrative system to displace this, that it would have been a more efficient administrative system than the administrative system that evolved from the knowledge of the parties to the action, both the plaintiffs and the defendants who have the same interest in reducing transaction costs. Neither of them gained by the transaction costs. They both lose by it. And so therefore, they both have an interest in reducing those transaction costs, and the courts had a great interest in reducing the transaction costs. So indeed, to have the very people with the greatest expertise devising the administrative system, which is essentially what happened, it's hard to believe that a government would have come up, or a legislature would have come up with a more efficient one. With respect to the state attorney general litigation, well, this clearly is regulation by litigation and taxation by litigation. I don't have any dispute with this characterization. This is an accurate characterization. But, you know, I'm sort of like, so what? Which is, so there was a tax on cigarettes. Sounds good to me. It reduced cigarette consumption. Cigarette consumption is consistently decreased. The biggest one-year decrease in tobacco consumption, cigarette consumption occurred in the year after the Master Settlement Plan, Master Settlement Agreement. So it had an effect. It had an effect that should have had. That the money that the states have used it for hasn't all gone to Medicaid payments. Well, money's fungible. What they spend it for now, what they spend it for later, money is fungible in that regard. It enabled the states to pay the Medicaid without having to take it from somewhere else. Did the multi-state agreement help the tobacco companies? There's a suggestion that it created a cartel, pricing cartel. I don't see the evidence for that in the book. The fact that it is like a tax results in everybody's prices increasing equally, and therefore everyone's prices go up, and therefore there is price parity. And in an industry where indeed 80% of 80 to 90% of the cigarettes are made by 3 companies, price following is you don't need collusion in order to have essential price fixing in such an industry. Indeed, one of the interesting things that came about was because of the master settlement agreement, there was more competition with the big companies, and so that the market penetration of competitors has increased since the master settlement agreement, as people who were not subject to that agreement have gotten sort of a price benefit so they can compete against the big companies. So it's even increased competition, reduced cigarette consumption, and provided funds to the states. I can't think of anything sounds like good to me in that regard. So bottom line, as I go through this thing as a summary, the book fails in several regards. First, while public choice theory certainly provides valuable insights into public decision making, I don't need to deny that, it's not a comprehensive explanation of public decision making. To reduce public decision making, whether litigation, regulation, or legislation, to simplistic notions of costs and benefits to players doesn't adequately explain the public decisions. Instead, misrepresents them in important ways. I don't know if it's a 40-watt light going on in the corner, or whether it's like the blind man feeling the tail of the elephant, right? And thinking he knows what the elephant is all about because he has the tail in his hand. It's an insight, right? But it's not a full explanation. The idea that people always act in their self-interest, right? When self-interest is so different for so many different people. As John talks about different self-interest from a litigator, from a policymaker perhaps. But there's the people there are actually people in government who do something because they think it's in the public good. Now, they get rewards for that, right? Their families like them. They feel good about themselves, all right? It's a reward, all right? But if that's what we mean by self-interest, then it's a non-explanatory system, right? Because it just means everybody does what they do because of something, and it just doesn't explain it. So the idea that it's all this sort of self-interest thing is just not adequate. It's an important insight, but not adequate. Second, book's 3 case studies all represent all of them as a failure. Right? And the question that I think you have to ask is, well, what if there hadn't been that litigation? Right? Would there have been regulation of the diesel manufacturers? Would it have actually resulted in something? I mean, it did come up with the increased 2004 regulations. This increased it, whether it did a particularly good job of another question. In asbestos, what was the alternative to asbestos? If there hadn't been Burrell versus Johns Manville, what would have happened, right? It just would have meant a lot of people would have been injured without compensation. In terms of tobacco, what would have happened without the master settlement agreement? It has resulted in the biggest change in tobacco consumption that we've seen in this country. The idea that litigation might spur some other activity because regulation isn't possible. We're now faced in the United States with the question of whether or not we're going to have a cap-and-trade program for greenhouse gas emissions. Some people think that's a good idea, some people think that's a bad idea. But there's a lawsuit that was decided, or not decided, but an important decision in the lawsuit that was made on Monday in the Connecticut versus American Electric Power Company, which is directly pertinent to this group, because it is indeed regulation by litigation, where it's a lawsuit brought under a public nuisance theory by Connecticut and environmental groups against major power companies emitting carbon dioxide into the air and seeking an abatement order, not damages, but an abatement order that would take the court to essentially decide how much carbon dioxide these companies could do. And that's there simply because there is no regulation, because regulation has not been possible. Right? And the fact that this litigation might spur regulation shows the dynamic in our system between regulation and litigation, that one isn't a substitute for the other, or the other is a substitute for one, but that they are together a dynamic connection. Third, another thing the book omits is a recognition that regulation by litigation is neither new nor unusual. Right? The suggestion that Robert Rice says we have a new tendency. I'd like to remind you about the Sherman Antitrust Act of 1890, right? Which established that it was illegal to engage in unreasonable restraint of trade, which was to be enforced by the courts in litigation. Right? And so, indeed, the Federal Trade Commission Act until the Magnuson-Moss Warranty Federal Trade Commission Improvement Act of 1970-something or other, essentially all antitrust law was made by litigation. Right? That was the way we regulated. Most of the independent regulatory agencies did their regulation through litigation. Remember the NLRB for always being beaten about the head and shoulders, for always making policy by adjudication, not by regulation. And this is it's widespread. And one could say that regulation is the rulemaking is the new boy on the block. I might note that some things like the civil rights movement, integration of the schools, regulation of schools by federal courts occurred. Again, regulation by litigation. And again, why did it happen? Because it couldn't be done any other way. Finally, it seems to be a subtext in the book that regulation, that they don't really care about due process. All right? We keep talking about how this regulation by litigation is not due process. But of course, it doesn't deny due process in the legal sense of the term. Right? Due process, as the Supreme Court has defined it, certainly been met in the individual litigation cases. In rulemaking, there is no due process, as the Supreme Court told us in Bimetallic Investment Company. So it's not due process. What seems to be the question is, there's no cost-benefit analysis, right? There's no OIRA oversight, right, of regulation by litigation, right? And that's the problem. And that's a problem because if you believe in the public choice theory, that regulations are being made by people's interests, rent-seeking, and so forth, and not by rational cost-benefit analysis. Rational cost-benefit analysis, or I might say formal cost-benefit analysis, that objectifies and monetizes all the values that exist, that eliminates public choice problems because it eliminates self-interest. It objectifies everything so there is no self-interest, there is only the public interest. And so if you believe that cost-benefit analysis, formal cost-benefit analysis can do that, then regulation by litigation is anathema because it avoids that cost-benefit analysis. Now, the public participation, as John points out in his paper, there's at least as much notice and comment on settlement agreements as there is in rulemaking, and one might say the court, in getting it as at least an independent body, deciding it as opposed to the agency that proposed something in the first place and us being asked to change it. So that's really, I think, the question that this book raises, right, is are we talking about cost-benefit analysis that is a necessity to avoid public choice problems? Thank you. Thank you, Bill. Sherry?
Delighted to be here. Thank you, Duncan, for the invitation and the opportunity to read again and reflect again on the contents of this book, which raises some very important questions and presents some really interesting material. Others have written about the asbestos litigation and others have written about the tobacco litigation. So I think it's not by accident that much of the conversation, much of Bruce's opening remarks even focused on the heavy-duty diesel engine case, because that is a real gem in this book. It is really the first full exposition of the EPA's approach to NOx reductions from diesel engines. And in that regard, it is blazing new territory. I would note that it's territory that others are already following. There was a piece just about a year or so ago in the journal Law and Policy, published by Robert Kagan of UC Berkeley, a law faculty, a political scientist by training as well as a lawyer, on some further work on heavy-duty diesel engine regulation. And I've also been including this case in a project of mine focusing on focusing on some of the unintended consequences of performance standards or performance-based regulation, which is what emission standards are. And I think that actually is also one of the real gems of that case study and of this book, is it offers an important lesson about unintended consequences of policy decision-making. The authors recognize that policy decision-making in any venue or forum can go awry. And in this particular case with the diesel engines, I think the real contribution is the focus on this pre-buy phenomenon, which presumably one would think, in hindsight, that should be something that one should factor in and anticipate that companies will pre-buy some of the older vehicles before the new technology is enacted. But it's a little bit like the black swan phenomenon here. It was just not fully recognized, at least when it estimated to the extent it would occur. And I think that's very helpful for anybody interested in making better public policy to think about. So I applaud that effort, and I also applaud some of the colorfulness of the metaphors that are used. We move now beyond Baptists and bootleggers to buffaloes, and I thought that particular metaphor was quite engaging. What I want to do is focus my remarks on what I see as the two main objectives of the book. One objective is empirical or explanatory. The other objective is very self-consciously normative. So let me focus first on the explanatory part. The aim there is to explain what triggers regulation by litigation, recognizing that decision makers face choices between different avenues of proceeding. Why is it that sometimes decision makers, particularly in administrative agencies, would choose litigation as a lever to achieve policy objectives? That, it seems to me, is the central question. And the answer here is, as already been articulated, is to see the explanation in a public choice framework where individual decision makers are acting on the basis of the costs and benefits that they are facing, both from their own personal preferences, but also from the kind of rewards and sanctions that they face in the environment in which they have to face a decision. And that seems a sensible general framework. What I think emerges from this book is a very interesting set of hypotheses or empirical claims that emerge, I think, perhaps somewhat disappointingly, only on the last 2 pages, where you outline what strike me as a really nice set of hypotheses. And I say this is slightly disappointing, and I'll get to it a little bit. Well, I think you probably only get to it at the end. But the hypothesis is you're going to see this regulation by litigation under 3 conditions. And in fact, they make a very strong claim, and they say this will only happen under these 3 conditions. You have a concentrated group of defendants. You have the plaintiff has a large hammer to exact a settlement. And third, that the ultimate deal has to protect the settling defendants from new entrants who won't be subject to the constraints imposed in the settlement. I think that's a wonderful set of propositions to test. Now, how do they stack up? I guess you've got 3 cases largely here, 3 chapters. What I was struck with is that one of these cases doesn't fit those conditions at all. If indeed regulation by litigation is possible only under these 3 conditions, how do we explain the asbestos case where there weren't? As you say at one point they were a small group, the asbestos suppliers, but there were over 8,000 defendants in this case. So at least one of the cases doesn't seem to fit those 3, and maybe the claim needs to be tempered a bit that regulation by litigation is more likely to occur under these 3 conditions. Maybe it occurs under other conditions as well. One of the challenges, and this is why I think this hypothesis and this theoretical framework and prediction comes at the end, is that you only have 3 cases here. And from a standpoint of social science research, you have 3 cases, you have an array of explanations for what's going on in these cases. You've heard some alternative explanations that John and Bill outlined here. You outline on page 77 a series of about 6 other alternative hypotheses that some of your sources identify to explain EPA's behavior in the diesel engine case. So you have a vastly overdetermined, the problem of overdetermination. All these explanations for just a limiting case. So it's not surprising at the end that what you can do is generate hypotheses rather than test it. And you recognize in the book this. I mean, this is not, in saying this, it's not something I think you didn't recognize at all. You recognize that the aim is to generate a conversation, that you don't have enough data points, you say, for any formal statistical analysis. That's fine. But it does mean, perhaps, that the claim that you make after you outline all the alternative hypotheses, the claim that you make to have found the most convincing explanation, either A, should have been tempered, or B, at least should have been accompanied by an additional explanation for why these other alternatives really are not as convincing. I do think, though, that there are that we ought to take the empirical claims here as opportunities for additional research rather than for anything definitive, lest we go the route that others have gone with case studies and reach broader conclusions than they simply can bear. And as somebody who has written about other areas where legal scholars have made broad claims and conclusions based upon limited case studies and found that they don't bear out, and I'm thinking here of all the case studies, including ones that Bob Reich wrote about negotiated rulemaking, where in a handful of cases it seems like this is really a panacea, but in fact, when you collect the data and you look across all of the examples, it doesn't hold true. I'm thinking also of the vast literature on the ossification of rulemaking, largely based upon one case study, Jerry Mishaw's book, David Harf's on NHTSA. And when you actually look at what NHTSA's done over the course of years, they've done an awful lot of regulating. So we have to be careful and cautious. Now, the question and the challenge, I guess, for you, if you're going to take this further, or for all of us, if we're going to pick up this line of research and test out these 3 conditions, will be to develop a larger data set of regulation by litigation, which then necessitates a very clear set of criteria about what counts for regulation by litigation and what doesn't. And that is where the kinds of concerns I think that Bill was raising about, well, is this anything new or not, become pertinent, because we have to distinguish now between the kind of litigation brought by regulatory agencies that might be used to lever some kind of injunctive relief, versus tort litigation that bankrupts people. The kind of criteria that you outline for defining regulation by litigation are ones that sweep pretty broadly, the litigation that's forward-looking. Well, in a common law system, any precedent is, in a sense, for anybody looking at that precedent, forward-looking, right? Because it'll guide future courts and future cases. And of course, injunctive relief, which has a long history in our legal tradition, is explicitly forward-looking. So is anything where there's injunctive relief forward-looking? You say it should account for, or what they say, effective substitute for a generally applicable rule that is capturing a large portion of industry. A lot of individual tort actions effectively regulate a large industry. If you looked at the temperature of coffee after McDonald's got hit with its famous lawsuit about probably the change, right? So does that mean any tort litigation that leads to some systematic change within an industry is regulation by litigation? The third characteristic you call attention to is settlement. It's more likely, you say, that you'll get regulation by litigation or settlement because it seems to me you say regulation by litigation almost by definition involves the plaintiff in effectively getting relief that the plaintiff could not have otherwise achieved through court. That exceeds, as you say, the unambiguous authority otherwise existing. Well, this also occurs all the time, right? Criminal plea bargaining, has agreed to alcohol or drug rehabilitation, which might not be actually part of what the sentencing guidelines might be. In the environmental context, people plea bargain all the time and say, I'm going to install an environmental management system, and that happens a lot. So, now maybe the definition of regulation by litigation is the combination of all of these three factors, but it calls out for a good bit of precision if going forward people will respond to this work and by drawing on larger sets of data. I do think, I think Bill mentioned this as well, I do think there is a real question about whether the asbestos litigation fits even your criteria for regulation by litigation, because it didn't seem to actually generate, at least in the way that the other cases did, some kind of norm statement or rule that was prospective or forward-looking. It was the economic consequences, the bankruptcies that were significant. Okay, so those are some questions that came to my mind about the explanatory aspect of the piece. Let me say a few words about the normative dimension. And clearly you have laid out the claim that regulation by litigation is problematic. And you say, in fact, that there's no benefits at all from a regulation by litigation from the public's perspective, and that there are substantial costs. Well, there's two types of problems that might come about from regulation by litigation. And I think these are definitely things that we ought to be concerned about. One are problems about the substantive outcomes that emerge from regulation by litigation. Is the world actually made a better place or a worse place because this litigation takes place? And you argue that it's going to be worse, and almost inherently worse because of the process deficiency. I want to talk more about the process problems, but because there's this lack of information that comes to the regulator, the decisions will be worse. Well, I think a stronger case for the outcome problems or substantive outcome problems of regulation by litigation would have been, in the diesel case, for example, to actually lay out what the net benefits were likely to be under the scenario of going forward with all the SIP revisions and the like, and compare that with the net benefits under the regulation by litigation outcome. You lay out very convincingly that the net benefits under the regulation by litigation account were negative, right? There were negative net benefits if both this was costing the industry to comply and because of the pre-buy phenomenon, air quality actually got worse. Okay, that's very convincing. But what I didn't see, you would want to see to really be convinced about the outcome problems, was how bad would it have been with the SIP problems? We may well have spent, the negative net benefits in absolute value terms may have been much larger, right? And so that would have been more convincing. In terms of the process problems, you do say that this due process argument, you say that the more serious cost of the diesel regulation by litigation relates to the integrity of the regulatory process. Here, I was troubled by a couple of things. First, there was a bit of a circularity in your argument, because the process problem, you said, is that there was this lack of participation. And yet, when we go back to how you define regulation by litigation, remember that third prong of your definition was that there occurred settlement. And by definition, regulation by litigation, you were saying, is a situation where there's a lack of public participation. So all at the end you're doing is saying, well, the reason there's a problem with regulation by litigation is because it's regulation by litigation, right? So that's something to try to break out of, and tell me why lack of participation is a bad thing. You do that when you say that it fails to generate the information. I would have liked to have seen you consider the ability of litigation also to generate information, because the kind of information that's submitted by industry participants in the rulemaking process is presumably self-serving information, whereas when a defendant is faced with discovery in the litigation context, it may be better. The agency may be able to get more accurate information. And finally, you mentioned that participation itself, the reason we want it is because it creates legitimacy. I wasn't clear what you mean by legitimacy here, because there are two ways of talking about it. One is sort of in the ideal sense. The other is in what do members of the public themselves feel about a system that lacks public participation, right? So there's legitimacy is used in these two senses in the broader literature on legitimacy. Either we're making an independent moral assessment of the legitimacy of this process, or we're worried about what the public will think about it and how much support the public will give to this process. If it's the latter, you have to keep in mind that courts and the court system, even when cases are settled, do, I think, cast a patina of legitimacy around things. So whether it's right or wrong, courts do tend to confer legitimacy as an empirical matter. So those would be some questions I'd raise about the process problems. Finally, and this relates to the process problem, I had in my own mind a question about how far you would want to take your normative critique of regulation by litigation. Do you want it to extend to any instance in which the government alters the incentives of private sector actors to do something that they wouldn't, that's somewhat costly and they wouldn't do on their own anyway? And I mention this because a big effort at the EPA over the last 8, 10, maybe 15 years has been to try to create voluntary programs and to create rewards and incentives to try to encourage industry to go beyond compliance, to achieve gains in environmental performance beyond what they would do otherwise. And that's been viewed by many people as a good thing, because if industry can regulate itself, they're more likely to do so in a more sensible, less costly, more effective way than government. That's the claim, and I wondered if you had any thoughts about that particular phenomenon, or whether you think that any kind of self-regulatory action, even outside the context of litigation, just even with the threat of litigation, the chemical industry created the Responsible Care Program after Bhopal because they were worried about new tort liability. So in the end, thank you for starting the conversation. Thank you for letting me participate in it. Thank you for raising the questions. The fact that a book raises questions does not by any means make it a failure. I think it makes it a success. And if this book actually goes on to inspire a new generation of students and scholars to take up these questions, it will be a great success. Thank you.
Thank you, Carrie. Andy, the floor is yours.
Yeah, well, I realize I'm standing between people and caffeine and...
You can quit right now if you prefer. Does that work?
No, that was my excuse for...
Okay.
Only offering. So, thanks for cutting back. You know, I've never before had anything I worked on compared to a Kurosawa film, so I'm very excited that I've been a part of a version of Rashomon in some way. And I really thank, on behalf of all three of us, the three commentators for taking so much time and doing such a fabulous job going through the book. I guess the main point I pick up on, since everybody talked about diesel, is to talk a little more about the diesel. And the larger point of, you know, how much can we do with public choice to understand this? And in particular, John's point that understanding how agencies work is actually really complicated. So necessity models simplify, right? So someone said at a conference I had recently, if you wanted to get from here to Champaign, Illinois, where I live, you wouldn't want a one-to-one scale map because that wouldn't be that helpful. So we have to simplify, and there's always the question, have you oversimplified, have you left off a major feature of the landscape? And this really is a first cut it in that sense, and understanding how agencies work and understanding the internal dynamic within EPA, I think, is really important. And there are these multiple stories, and so John's story is also a convincing story about the role of enforcement. I think in some of our earlier drafts, we put more emphasis on the enforcement players as kind of entrepreneurs, maybe not with quite as nice a motive set as John gave them, but seeing them as seeing their advancement and their opportunities, and also their chance to do what they came to do, right? I mean, it is true that people go to agencies, and if you're at EPA, well, the reason you're at EPA is you really care about the environment. You think EPA is really important, and so you should have a bigger budget, and you should have more resources, and you should get the bad polluters, and so forth, which isn't quite the incentive set that the policy people have. So that when we talk with the folks at the Air Office who disagree completely with our interpretation of their behavior, but were very generous and kind in talking with us, their account really was of the enforcement people as disruptive to the relationships that they had created with the industry, and they were sort of annoyed about it because a lot of time getting good relationships so we can get data and understand what's going on, and enforcement guys come in and sort of swagger around and wreck it, which was consistent with the story the diesel folks themselves told of the meetings that they initially had with the Air Office discussing, okay, we've discovered that we have a little bit of a problem here, and we think the problem is related to your use of controllers, and we need to work out some way to fix that. And then the next meeting, there was this enforcement guy there, and the diesel folks' lawyers said, shut up and leave the room, because now we're in really big trouble, and it changed the dynamic. So future work is necessary, right? Modeling agency behavior is really important, and understanding those incentives, absolutely, there's more to be done there. And I hope the conversation can talk about how that might happen, because trying to pin that down would be really useful, no matter what you think of the outcome. With respect to Bill's comments, particularly with respect to tobacco, I would disagree, obviously. And I disagree in this way. If it seemed to me in a sense that you were saying that, well, the outcome's pretty good. You know, we've got a tax on cigarettes, and that's good because fewer people bought cigarettes, and then we got more competition, and that's good. But more competition is really good because the price goes down when you have competition. And I think our problem with the MSA was not that cigarettes aren't bad, although I think maybe we would let people make that decision more on their own and give them less of a nudge in the current descriptive way toward not smoking. I'm not left with much sympathy for cigarette companies, but I actually have a little more than I started with, because as bad as they behave, they actually seem to get beaten up in ways that are bad as well by people that I've ended up liking less, like Dickie Scruggs, as a result of this. But what was really problematic, I think, about the MSA was it wasn't just a tax, right? There was a lot of substance in the MSA. And I don't feel comfortable with some private lawyers who went to college with some state attorney generals working those things out on their own and then presenting it as a fait accompli, more or less. No, it was ratified by the legislatures, absolutely. My faith in legislators when someone says there's a big pile of money if you just sign here, from a functional point of view, I'm not sure that the deliberation was enormous. And I am actually worried that the states have now switched sides. So from a state point of view, what we're really interested in, and we've seen a couple of examples of this, Florida, for example, have intervened on behalf of the tobacco companies on some points in some of the litigation over smokers, saying, our revenue stream depends on this company continuing existence and continuing to sell stuff. So we're not happy with some of the results in litigation. So Florida is a great example because it was completely unprincipled changing law to enable the MSA, to enable the lawsuit in the first place. And then they changed the law on the other end to make it tougher to get supersedious bonds and things like that of a sufficient size. So the incentives for the states, I think, got changed by it as well, and that's problematic. And then on the, I guess on Carrie's comments, I would agree that we need more data, and there needs to be the kind of work that he did on regulation by negotiated rulemaking that really popped this bubble that had come on. That this was really going to be this great thing. We're all just going to sit around a table and everything would get worked out. And it turned out it was just this tiny, tiny fraction of cases and didn't actually make anything better by any measurable criteria. And it turned out the counting was all funny and stuff like that. So the next step really is to try to count some of this stuff. And I think we could be clearer about, and will be clearer in the future about what the definition is of regulation by litigation. Although I'm not completely convinced that it's as loose a definition as we had. Our definition is as loose as perhaps you thought. So I'm going to try to think a little more about why I think it's not quite so loose. And maybe Bruce or Andy will have something to say about that later. But you're right, everything is forward-looking in the sense that the precedent is forward. But what's forward-looking here is the saying, from now on you will do these things, not the lawyer saying, well, if you're smart, you'll do these things. It's, you will do these things going forward. And I think that's a little bit different than a lawyer's advice based on a precedent. And the effective substitution for a rule by capturing a large portion of the industry, yes, tort awards can have that impact. I actually think it would be a great project if somebody checked with coffee shops to see what temperature they serve their coffee at, because there is evidence that consumers prefer it really hot. And so I would guess actually that small coffee shops continue to serve it very hot, and that large corporate defendants with legal departments have cut the, so McDonald's probably cut the thing, and Starbucks probably cut the thing, but Joe's Coffee Shop, that would be a great graduate student project. But
you have to sample all of them.
Yeah, well, that would be the professor's job. The grant to travel, the foundation might investigate that. But what's important, I think, is a difference there is that in this settlement process, it's true that there is participation by the immediately regulated people. But for example, in the diesel case, there wasn't participation. In fact, excluded from participation were the people who bought the engines, the truck manufacturers, who were sort of standing outside the courthouse waving their arms saying, wait, this is a bad idea. We can't do this. And which fed into the pre-buy, right? So, and their description, at least, of their meeting with EPA, when they went in and said, you know what's going to happen, Doug, was that the EPA people turned white, canceled their next 3 meetings, and sat around trying to sort of come up with a way to fix this, which they didn't. Now, EPA might have a different story about that meeting as well, but the exclusion of interest groups who would have the opportunity through regular rulemaking, I think, is a serious problem in terms of generating information, because it's true that that's not subject to cross-examination, but it is subject to comment by other people. And there is some sense that if you throw in phony data into the rulemaking, somebody else is going to notice, and there's a competition there to present information. So it's not, and because of the settlement, I'm not sure how much information actually gets generated, because, for example, the diesel case, it settled quite quickly without the opportunity for much discovery. But anyway, I do want to thank all 3 of you for taking so much time and putting so much effort into very helpful comments.
The last thing I'll throw out, and there's a case that I actually have in mind, is that thus far, I think in literature related to regulation by litigation, the assumption has been, and this may be a fair characterization of our book authors, that the primary critics of regulation by litigation are also more generally critics of regulation, and see regulation by litigation as a shortcut to get more governmental or coercive control of private behavior. But is that always necessarily the case? In 2007, July 2007, the DC Circuit decided a case called, and this is actually the name of the group, Association of Irritated Residents, in the acronym AIR, versus EPA, and their claim was what the EPA had done with regard to concentrated animal feeding operations was to, rather than issue a rulemaking and regulate their air emissions and impose all sorts of burdensome requirements, initiate enforcement actions against something like 90% or something of the industry, and then enter consent decrees with all of them where the EPA said, we will defer any enforcement against you if you promise to provide lots of information to us, so at some date in the not so distant or perhaps even distant future, when we bother to get around to issuing a regulation, we will have information to come up with a good regulation. And the Association of Irritated Residents sued, arguing that this was the use of the enforcement process, not to get greater regulatory control of the industry, but to in fact prevent and forestall regulation. And so they sued that this was the use of this tool to do the opposite. And the DC Circuit, in a divided opinion, said no. This agency says we've seen other outcomes have a bunch of tools, and they get to choose. And this was an enforcement action, and enforcement actions often result in deferred prosecution agreements. And that's what happened here. And it doesn't matter if it was 90% of the industry, or it doesn't matter if they might otherwise let it as the regulation. We need to do this. But the end result was arguably less regulation, not more. So I would just throw that out as a case that I find really fascinating, and I'm constantly telling students if they want to choose the administrative law case that hasn't really been written up, this is a good one. Please don't tell your students that. Anyhow, the queue is open. I know Jack had a couple points he wanted to make, so I'll start with Jack. But again, if you're going to be on the queue.
Okay, good. I had actually 4 points I can make as fast as I can, not by talking fast, but by not saying everything that can possibly be said, because I admire actually Carrie, John, and Bill for being able to squeeze so much into a relatively short comments. And first thing I want to say is I agree that the book was very worthwhile reading. I really got a lot out of it. I think there's a lot of very interesting stuff. I wanted to first a couple of basic administrative law points. One thing is that there's a long-standing administrative law doctrine that says that it's really in the agency's discretion whether to proceed through rulemaking or case-by-case adjudication. And Bill, you sort of lump this regulation by litigation as case-by-case adjudication. I don't think that's right, actually. And I think what this led me to believe is that there's actually three choices agencies make. And the two, rulemaking versus adjudication, both involve developing the norms within the agency, which then can be subjected to judicial review if these regulated parties don't like it. The third thing, which is something that has happened, like the FTC has basically stopped having any sort of cease and desist hearings on consumer stuff. They just go right to court with enforcement. And so the other choice is to jump into court for enforcement without a pre-existing norm that's already been developed in the agency. And this, I think, is a way of characterizing what was going on a little bit about the diesel thing. That it's unclear. I tend to think it's the enforcement of existing norm, but there's this problem with the fact that they've been letting it slide for so long. So maybe what needs to be asked is whether, as a matter of administrative law, that third choice of jumping right into court to bring an enforcement action when there's not a pre-existing clear agency norm is something that's going to get the same sort of deference, or whether people are just going to sort of step back and say, no, that's just the same kind of choice, and we're going to let them do it. I think maybe there's a difference, and it's something maybe on a public choice matter, you might want to do research on when they choose it and why, and maybe that helps. And this is a step towards that. I mean, obviously, that's a thought that provoked. The second thing that I thought of was that there's a lot of abusive class actions out there, which are really collusive lawsuits, and the feeding one, I think, maybe fits into that mold. The current, and that's a public one, and then the private one I'm thinking of right now is the Google settlement, where a group of lawyers is claiming to be representing all authors of books, and really what they've done is they've colluded with Google to try to get a big licensing fee where they get $30 million in what they call legal fees, which is really a commission on the licensing that they're, and then meanwhile all of us who are authors of books, we lost all our rights. And we could obviously opt out, but there's so many abusive class actions, and there's some great literature on the abusive class actions in the asbestos area, and I think that's an area where I think there could have been more attention, and where I think it would help maybe distinguish a little bit of the government versus private kind of class action cases. The third thing was, this very short point, on a public choice matter, it's really funny to me that the agency is worried about the political costs of enforcing a statute. They're worried that Congress will be upset at them for enforcing the words Congress wrote. If you want to encapsulate in one short thought what public choice can tell us about how crazy the government works in so many ways, that's it. The last thing is I want to focus for a minute on one of your normative points you make right at the end of the book, where you say that once there's a norm, that norm should govern, and the agency shouldn't be able to go and undercut it through litigation. And what you were referring to, I think, without coming out explicitly, was the norm that says they could use these controllers in the diesel engines, that then was undercut when the enforcement people came in and said, for 15 years, you've been letting this slide, by the way, it's illegal. It seems to me there's two reasons to reject that suggestion. The first reason has to do with the idea that what you're doing then is you're letting an agency bind the successor administrations. And it's a big problem in our system and Susan talked about the midnight regulation problem yesterday, that one thing that every administration likes to do as much as possible is project their agenda into the future. So, and there could be also the projection of mistakes into the future. If someone in EPA realizes that, hey, for 15 years we've been messing up and not enforcing it, and maybe that's because the norms people have a cushy relationship with the industry, maybe for good reason because it helps overall cooperation, maybe for bad reason because it helps future employment. For whatever reason, it seems to me that you don't want to hamstring the new administration to come and say, enough, failure. It may be that the new administration is wrong. Maybe the new administration is trying to do something bad. But for whatever reason, I would not say that a course of conduct by an agency over even a long period of time should, if the law doesn't absolutely actually support it, if there's not discretion, it shouldn't bind it. And on the private side, what you're talking about is allowing agency approval to preempt state tort law. And I don't think you were thinking about it, but that's the implication. So when FDA approves a drug, there should not be a product's liability brought on that drug. FDA approves a medical device, and you can multiply that. The problem with that is that all the public choice problems with rulemaking are much, much worse on individual approvals, where it's much lower, it's below the radar screen. And so we've seen a lot of incompetence and corruption at agencies when they approve, like the generic drug business at the FDA, for example, that come out in scandals. And I would not want to have any norm which says that any time the federal government approves something, that means that there's no way through litigation to attack it. I think that the attempted expansion and somewhat successful expansion of preemption during the Bush administration is a terrible thing for product safety, and it's basically undercutting all kinds of the real way that we regulate product safety, which is through product liability litigation.
Q, I have Mike and Jim and Bill. Mike.
I want to echo some of the comments in that I'm not sure how far the public choice explanation cuts. And let me try something up. What at the end of the day makes you nervous about these cases, right, is that the sort of decision heuristics or the matrix within which people make decisions in these litigation settings are all wrong and probably not conducive to anything that gives you any reason to be confident about the outcome. So we just mentioned 4 things that, to my mind, make this different. I mean, make litigation and settlement different from regulation. So the first one, Bill mentioned this. I mean, what you're upset about is not the lack of due process. That's not it at all. It's really the lack of any systematic reasoned analysis of what is about to be done here, right? And you can call that cost-benefit analysis. It may take some less formal way, something like that, some reasoned examination of the measures at issue. And that is a flip side. What is it that drives these things, if not some notice of common cost benefit, if not something like that? What is it that drives these kinds of things? And there can be only one answer. It's the settlement incentives, right? And so that's probably not, that may not make a big difference if the party on one side of the table is a federal agency, which would otherwise proceed by regulation, like the EPA. It's a huge problem to my mind. If the parties are private attorneys, right, like class action lawyers, and the industry on the other hand, or some attorney general who does this against the wishes of, let's say, securities regulators who are formally in charge of these agencies, who have absolutely no responsibility for that industry at all. Because in those settings, there's nobody at the table who has any kind of incentive to get it right. And all that drives it is, what can I get out of it for myself, for the other party, and so forth. And so that's a useful, I mean, I don't mean this just purely in a normative sense, it's a useful research question, right? I mean, are there settings in which you don't have to be nervous about party settlement incentives, and are there settings in which, you know, we should say, oh, that's really a bad way of going about it, and even if the regulatory process by some responsible agency would be messy and confused, it's bound to be better, and presumably there are ways of finding that out empirically. The second thing that makes one nervous, or might make one nervous about the decision matrix or heuristics here, is that for the most part, these interventions and these settlements are interventions, piecemeal interventions in a very, very complex regulatory environment, right? So the trucks are only part of the bigger sort of NOx picture, right? And if this actually played out the way John described, that the enforcement guys there said, oh, damn it, you know, drop the hammer on these guys, that makes me even more nervous than their story in its own way, right? It might very well be true, right? Because it's not part of the bigger picture. I'll give you another example. Now, all these settlements about average wholesale price settlements, right? So these are these arrangements where basically, with public knowledge, with congressional endorsement, we allow drug manufacturers to kick back money to doctors. Why do we do this? I mean, it's an insane system. Everybody agrees it's an insane system. Why do we do this? Answer, because otherwise that's what it takes to keep the doctors in the Medicare system. Because if they didn't get the kickbacks, they'd demand higher rates or exit the system. That's the absolute last thing Congress wants, right? So, in stroll these guys from Hagen's Berman and say the whole system is a fraud. Yeah, well, in their own way, they're all right. But they're unsettling something that's much larger than just the average wholesale price thing. So now, in its own way, it's of course also true of regulation. That's always sort of, you proceed one piece at a time, but maybe you do it sort of under the auspices of an agency as opposed to sort of, 50 courts out there. There's a little more chance of a sensible outcome. So that's the second piece. The third thing, and this is actually, again, something that in looking for additional empirical cases, and I agree, the stories are terrific, especially the diesel story. What kinds of cases could one look at? Well, if you proceed by enforcement and then use that for rulemaking, chances are you're starting with an outlier case, right? Some case where somebody really misbehaved, right? And then it looks to you that that's the normal case, right? But it isn't, right? Whereas in agency decision making, there may be a little more awareness that, no, look, we shouldn't sort of construct our entire regulatory universe from the worst case that or the obvious law breaking that we've just seen. There isn't a case like that in here. The tobacco guys, their crime was to do what they were set up to do, which is sell cigarettes, so that's not an outlier case, right? The diesel guys all did the same thing. There was no outlier there. Asbestos, asbestos is asbestos. So, right? But there were cases like that. The insurance broker settlement was like that, right? Where they found some guys who had stepped over the line and then took the entire industry apart. The examples like that, where we get very elaborate regulatory regimes out of something that was really an outlier case. And then the final thing I can think of is, and you guys mentioned that, and it came up in various comments, who is at the table here, right? And I think that is a really, really big problem. It's not so much that somebody didn't get notice in common. It's that the selection here is biased in a very, very peculiar way, right? There's the regulators or the attorneys on one side and the lawyers on one side, and then there's the regulated industry on the other side. And then, look at the MSA, the public health guys were frozen out, the farmers were frozen out, not to mention the consumers or the taxpayers or anybody else, right? It was just the guys from Philip Morris who sort of cranked this thing out at Rock 10 Lipton and then said, hey, we'll share the proceeds with you, and how much money does it take, right? How do you distribute $500 billion in monopoly rights? And that was all it was about. And that ought to make you nervous at some point, because once you restrict sort of the range of parties at the table to that set of people, there's no way that isn't going to be collusive. And all these cases, I think, have huge, it's demonstrable with the tobacco settlement. I actually don't agree with it. You look at, especially if you hate Philip Morris, you ought to hate this deal, the way that was done, right? They paid them unbelievable amounts of money. You look at the stock price of these things. And there's only two ways of taking it apart later, which is, erosion by people who cheat, who are the heroes in the story to my mind, the renegade manufacturers. Or else you take it apart in litigation because it's so massively unconstitutional. All of the stuff in the MSA you could have done directly by taxing them without paying Philip Morris along the way. So that's an obvious thing that was collusive. You look at the analyst research settlement, $800 million for what they were supposed to have done. That's what Morgan Stanley spends on coffee on a good afternoon, right? If what they did was really bad, that should have been much, much more, right? And they restructured the industry in such a way that the investment banks, until they disappeared for entirely different reasons, made a ton of money. Now that the parties may sometimes miscalculate, and then it's very hard to insulate these kinds of cartels that come out of this against the outsider tax is a different matter, but it's at least something to worry about at the outset. And there's a wonderful article by Ian Ayres on cartelization by tort settlement. I think that sort of outlines sort of the basic worry that you have about this. What all of these things have in common is, A, you can study them, right? The sort of decision-making characteristics, and B, that maybe, now, in each of these domains, I mean, the public choice dynamics might well play out, but it may be better to start the empirical analysis with the decision-making matrix as opposed to the public choice domain.
Was that a quick point, or is that a?
Oh, that's a very quick point.
Okay.
It's sort of a variation, perhaps more the same. If our question is with regulation by litigation, one of our important questions is, what is it? How do we define it? And then we get to, is it good or bad, and how do we measure good or bad? And on so this is related to your point about who is at the table. I mean, what is it function? It just struck me as instinctive and not as a divine, inspired theoretical matter, that there's a difference between a federal agency doing it, a private litigant doing it, and then the most interesting thing, the state's attorneys general, which have sort of an unusual role that is a little different from the two prior. I mean, you sort of see the federal agency and private sort of as the whole, and the attorneys general using litigation to reach beyond what they could do ordinarily, but it's a more interesting function, and maybe the most challenging of the three. So that's my small one.
Jim, some of my comments really are complementary to those that Michael made, but I'd like to cluster around four points. I think, to me, the main thrust of what raises and what we're addressing is the institutional competence of courts. I think that this is really the story, much of the story. It's not the entire story. I think Carrie made a good point about how agencies decide these questions. But for me, that's less significant than the question of institutional competence of courts. And I think the problem with courts is that they have a narrow analytical horizon. They are good at determining who ran the red light and who has responsibility for that and so forth. But administrative agencies rose in part because of these narrow analytical horizons, and it's very difficult to get spillover effects to be considered in a judicial proceeding. And where there are multiple factors and multiple parties, it becomes very hard for judges and for courts to really look at issues that are not either yes, no, or more or less, but deal with other kinds of trade-offs. And so I think a lot of the story here is that the micro perspective of courts is not really optimal for dealing with the kinds of regulatory goals and issues that the authors are talking about. And it strikes me that the question then becomes what kinds of legal rules are appropriate where agencies seek to litigate before they, as Jackson, before they determine internally what the document is for the agency should be through adjudication and lawmaking or rulemaking. And I think that things like intervention, the question is what should the legal system say about intervention? Should the trucking companies be able to intervene in an enforcement action where you paint the picture that they really wanted to get involved and weren't involved? I just recently litigated a matter where I had a consent decree and the newspapers came in, which would suppress information about arrest records of people who were not convicted because of the harm to those beneficiaries. Well, they claimed that there was a systemic interest in having access under the First Amendment to that information. So they intervened in the allowed to intervene. I think they should. That's of course a broader perspective. OIRA has grown up in part because we see that even with the agencies have a micro perspective, and there is an objective then to have a broader horizon, analytical horizon, and OIRA is in part a response to that concern. We don't have anything like that in the context of the typical adjudication model in a court. We don't have a vehicle or a tool for doing that. And the way I like to think of it is, if I'm a doctor and you're my patient, my interest is your welfare, but if money is being paid out of a common pool, Blue Cross or Medicare, there's also a macro concern out there about whether my recommendation to my patient should be a priority in terms of the allocation of common pool of money. And there has to be a vehicle for taking those broader kind of gross macro considerations into effect. So So that's the first claim, is that the courts are limited, we don't have good vehicles for doing this. One interesting development in this is in the punitive damage area, where we do have comparability analysis now, where you look at comparables for different claims, and the courts are being asked to review in the punitive damage context what other juries and other courts have done. That's kind of primitive attempt at bringing this kind of macro perspective to bear, but that's very underdeveloped. Secondly is the settlement question. And I think that the cases that were discussed in this book aren't even the worst of the worst. I mean, there are consent decrees where you have constant judicial oversight, you have delegation of what seems to be governmental authority to special masters or to district judges. And the school desegregation cases certainly fit into that category, but you have other kinds of institutional orders like managing mental hospitals and prisons and so forth. And my favorite example of this is a decree out of the Fifth Circuit. I think it was Judge Johnson, and I always like to talk about this. One of the requirements was that there be odor-free toilets. Well, there are limits to that's like humorous. It seems to me there are limits to what a court can order in institutional reform litigation such as that. And one of the standards then for revisiting these decrees, well, in administrative laws, the State Farm case, I think it is, it says you can't, just because you're new administration, redo a regulation without having some substantial reason in the record to do that. And in consent decrees, we have the Rufo case that says you have to have a change in fact or change in law, but there is this lock-in effect, and I think that there is, that's a real risk, is that one administration can lock in the next administration. And overall, I think the problem here is that once a plaintiff, whether it's a government or private plaintiff, can win on the liability phase, we have such a bifurcation between liability phase and remedy phase that the defendant often can't risk litigating and vindicating its rights under the liability phase without risking a tremendously open-ended, untextured, uncabined remedy phase because of our notion of the broad powers of a court of equity. And so, as I said to Carrie in the break, if somebody comes after me and says, you ran the red light, and I say, no, I didn't, I'd be inclined to fight that. But if they say, we're going to put you in jail for 50 years or have capital punishment, I'd say, where do I write the check? I mean, it's a pretty straightforward issue. And so there's a problem about, do we deprive parties of their ability to litigate the liability aspects because of the open textured, very highly discretionary, and potentially very damaging effect once we get past liability and get to remedy. And I'd like to put on the table here the Prison Litigation Reform Act, or the PLRA, which was a legislative response to this perceived, and I'm not going to get into the merits or demerits, but it's an example, the perceived overreaching of courts in institutional reform cases in prisons. And what the PLRA does is says that the scope of the judicial authority is limited to alleviating the harms to an individual prisoner. You can't, in other words, it's a least drastic alternative approach. You can't have one prisoner have a violation and use that as a vehicle for courts to restructure the entire prison. You have to only focus upon the harm to the individual. You're trying to put this into the model of A versus B, that you run a red light, rather than using a finding of liability as a tool, a vehicle, for redoing and restructuring the entire prison. And so I think that the PLRA is an interesting model legislatively to respond to kind of develop some of the proposals you're talking about. Easier rules for intervention, some notion of restraint on settlements and so forth, maybe making revisiting settlements easier and so forth. Third point is accountability of political control. And I would suggest there's another story that can be told, and that is that it's sometimes easier for political appointees in an agency to control litigation than it is, in a sense, to control the rulemaking process, which tends to be the professional staff. So if I'm sitting in as an agent of change in an administration, as a new Republican in a previous Democratic administration or a Democrat in a previous Republican administration. This is a pretty low transaction cost way of implementing my policy preferences, is by going directly for litigation. And as long as there's political sign-off, I'm a little less troubled by that, because you then would have, for example, the Bush administration and the Justice Department, they went after voter registration fraud. Well, the Democratic administration would see that as voter suppression, and they would withdraw that, as the Obama folks have. And so that is a more accountable in some sense. So I would say there's another way to look at that story about litigation, is that you can make the case that that is a easier way to exercise political accountability. And then, of course, fourth and finally, there is a risk of, and Michael said this, others said as well, police lawsuits, job force. There is the risk that a sophisticated agency will use its political clout to direct these lawsuits in a way that undercuts the regulatory agenda. This is Jonathan's example, but there are many examples of that where agencies use the litigation process as friendly defendants. One only has to look at the consent decrees in prisons and hospitals and so forth. Are the prison management folks, what is the Department of Corrections, a real defendant? Or do they see the court as saying to the governor, send us more money? We want to increase the number of guards. We want to build a new prison. We want to have more resources. And these settlement decrees then become tools for internal reallocation and ultimately coercive suits in that way, where the government is now saying, sue me, or engaging in litigation and then settling on favorable terms, as Jonathan's example suggests. So I think that that's another concern, that goes to the institutional abuse of the judicial process. And so I think the megacep, as I gather it, is really one of institutional competencies, and not technically whether there's a due process violation, but who's at the table. If you're not at the table, you're on the menu. That's the classic fear. And so I think that here, you really don't want the price of participation to be that you constantly will lose your business or lose your industry and so forth. You want to have vehicles by which this can be done and some kind of ability to challenge the market. So I think that's the story you're telling. It's very important.
Bill, Jordan, and Dennis, and then I'm going to give you others a chance to respond with, or you'd like to respond to that.
Jonathan said a little while ago that it seems that those who don't like regulation by litigation also don't like regulation by regulation. I suggest that if you don't like regulation by litigation, you should like regulation. Because why does this happen? I'm going to separate out the diesel case. I think it's a very different case than the other two. You're talking about harm happening to lots of people. Something is going to happen as a result of that. I don't know what's going to happen as a result of that. Something's going to happen as a result of that. So what we should do is adopt the precautionary principle, for heaven's sake, have really good, strong regulation, and that will avoid these somethings happening. Now, what's going to happen if we take a look at the irritated residence case? Well, they tried something, right? And they got knocked out. But what's going to happen from that? We heard about the public nuisance case. Maybe that's where they go next. They're going to go somewhere. They might go over the fence. Who knows what they're going to do? But if it's bad enough harm, something's going to happen. So what you really should do, for all the reasons we just heard, is have an agency looking at this comprehensively to come up with a regulation that addresses it, rather than having distortions that we get when we don't do that.
Yes. I want to speak to the normative point that regulation by regulation is better than regulation by litigation, and just raise some questions about that. First of all, I also really enjoyed the book. I thought the picture of regulation was somewhat optimistic, especially on the public participation, transparency, sunshine kind of aspect. In reality, especially when you're dealing with technical environmental issues, many members of the public can't understand or participate, so you get kind of special interests dominating that process. And also a lot, your story of regulation starts with the notice of proposed rulemaking, but often the various interest groups are talking to the agency well before, and the agency's quite wedded to the policy by the time it comes out in the proposal, and it's hard to move them off of it. So I'm not sure that public participation is as effective as it might otherwise be. So I think you're a little optimistic about rulemaking, and I think you're a little pessimistic about settlement. And when I think of settlement, I think of settlement more broadly. I mean, settlement of the litigation is one form of settlement, but other kinds of negotiated solutions are also settlement. And so, I would look at this settlement of the litigation as one form of negotiated solution, or kind of contractual regulation, as Jody Freeman has called it, consent decrees, regulatory negotiation, RegNeg. So I wouldn't necessarily break that out as a separate category. I would see settlement of litigation as a type of negotiated solution, kind of like regulatory negotiation. And I'd even go farther and look at other regulatory instruments like covenants between, contractual agreements between an industry and the regulators. And I kind of got interested in this in looking at the Dutch approach to codes of conduct and covenants, which have been used in the environmental area, also in the EU, where government negotiates a compliance regime with the affected industry. And there's a lot of dispute about the value of that process, but if you believe the claims about it, one, sometimes government can go farther, can get more stringent requirements in place than they would have been able to do through the regulatory process, so the environment can benefit. And also industry can get more flexible standards. The standards tend to be more flexible. They are more adaptive to changing realities because they're flexible. And they draw on the local knowledge of industry. And you guys talk about that so you can come up with more cost-effective solutions. So that's the story, at least, about covenants. One of the challenges there, of course, is accountability. Who is this going to be some kind of sweetheart deal between industry and the regulators? And then there's also a challenge if you think about using it here. Could we use such an approach? We have a much more litigation-based culture than Europe, and especially the Dutch, which is a much more consensus-based culture. And so part of the idea is that that kind of covenanting could work there, but it couldn't work here. At least that's what I thought, until I learned about regulation by litigation. And then I thought, well, maybe through this process you could have more accountability. After all, you've got a judge supervising the settlement, supervising the negotiation. There's your third party to make sure it's not some kind of sweetheart deal. And maybe we could adjust it to our culture, our litigation-oriented culture, by having these kind of negotiations in the context of a litigation or settlement of a litigation. And so I'll make a proposal. It's only half serious, but it is half serious, which is that we need more regulation by litigation, not less.
Good. A bunch of folks want to hop in real quick. They're all reasonably quick, so that really give all this a chance to respond. I have Bill, Karen, and Brian.
I wanted to say, we talked about different approaches, regulation by rulemaking, regulation by litigation, maybe regulation by adjudication, regulation by policy statement / interpretive rule, right? Which is important because it's a way of avoiding oftentimes OIRA, oftentimes notice and comment, and yet if you're going to get deference from the court because of what you've said, it is the effective way of regulating the industry. You tell them what you say, this is our policy, you expect the industry to comply, or else the threat of litigation occurs. So I think this is an initial thing that should go in that category of options.
To repeat what Susan had said yesterday, when you look at cost-benefit analysis, it's not the best solution, but it's the best that we have, when you look at everything else. I'm butchering it, but the point I make is, to your point that you just made with regards to the fact that rulemaking is imperfect and not all the interests are really at the table, I would argue the opposite as the representative of the small business owners. across this country in saying that there have been procedural protections that have been put in place by Congress so that we have people that know these issues in the environmental area and Department of Interior, all of the really technical issues there that are on, the government payroll in the form of SBA's Office of Advocacy, and have really been effective at the front end in the rulemaking process of getting and seeing the unintended consequences that are completely missed in regulation by litigation, so that at least some of the damage is tempered that can be done to the community that, quite frankly, doesn't have the resources to play in either of these venues in a real meaningful way. Small business owners just don't have the resources or the knowledge base. I mean, they are the ignorant in this area as far as being able to give the meaningful comments and seeing down the road how regulation is going to work. And so for that reason, rulemaking is our only option in my mind as far as getting it done in a way that is going to be less harmful to that segment of the population. And then with regard to Professor Fund's point earlier on just dismissing the tobacco settlement, do I know what has happened to small business owners as a result of the MSA? I have no idea, but I guess I am hesitant when I hear somebody be so flippant as, well, money's just fungible. I mean, there were people downstream that were affected by that, I have to believe. The people that were selling the cigarettes, at retail stores. I don't know, but I guess my point is that I hate to hear just a complete flippant, well, it's just money. Well, all that money is part of our economy, and people are impacted when it's large transfers of wealth are happening in a way that's really not thought out well and in a collusive manner in that instance.
I wanted to supplement John's comments in ways that you may or may not agree with. So in the interest of time, just shake your head up. But he's right. Going back to Bruce's opening statement where he described this hypothetical unitary rational decision maker, regulator, that's not a good model to try to explain EPA behavior, because there are lots of competing centers of power, and in particular the enforcement office has its own authority. It's very much compartmentalized. Other parts of the agency, including management, don't know a lot about what they're doing. Their motive, I think John described their motives well, and the attempt to separate policy and enforcement, but yet the people in the enforcement office have very strong policy views. They disagree with the people who are writing the regulations in their office. They disagree before the fact about what the regulations should say. They disagree after the fact about what they do say, what's intended by them. But they have their own ways of making policy. Their office writes regulations and permits. The enforcement office can litigate and sign consent agreements. I was surprised, for example, to find that something like it, when I got to the agency, 80% of the refining industry was operating under consent orders. That's what determined what they actually had to comply with. And the official goal of the enforcement office was to get that to 100%. Now, how can 100% non-compliance be the official goal of the enforcement office? You'd think it would go the other way, but that's paradox. They have. So one way to look at this is just competing centers. One office issues regulations, another office issues enforcement. There's a struggle to control what the actual standards are to apply to major sources and major industries. And what we're seeing is the result of that competition.
I think transparency in many different contexts is important. We took the obvious public rulemaking opportunity that anyone can comment 8 zillion members of the Sierra Club and mass email something, but also transparency on state attorney generals hiring private firms and giving them millions of dollars with no time slips. So all different kinds of transparency. And also an ongoing discussion as these are very complex things. So thank you everyone for coming and helping us, especially the commenters helping us clarify these issues.
I don't really have anything to add, but again, thank you all for taking time to come and participate. That's been very helpful for us.
I'll echo that, but I also want to revisit very quickly what I was hearing from a number of people. We need to be much more careful in defining what we mean by regulation by litigation. And I think as a result of what turns out to be the fuzziness in terms of our use of those terms in the election case, perhaps it leads us astray, but not in a wasteful sense, but leads us astray in terms of how this might be steered and so forth. That is, for example, on the antitrust case, when I was at the Federal Trade Commission, we had files of consent decrees that went back for decades. I never heard of one that applied to every member of an industry. And it is the rare antitrust case. The electric equipment case is the only one I can think of sort of in modern times where they went after practically every member of an industry in terms of antitrust. But we do know that antitrust and court actions and so forth end up with regulation, but typically not for every player in an industry. But when I'm saying this, I'm saying we need to do a better job of defining this territory. Richard Epstein, in his piece on this topic, when the question was raised, well, what would have happened had these transactions not occurred? Had we not had the settlement with the diesel, had we not had the tobacco settlement and so forth? As Epstein looked at this territory, he says, when the parliament, when the elected officials leave a vacuum, is where there are a large number of people who are adversely affected because of something, but the incentives are such that it's very costly for that large number of people to organize action. Then that is time in a democracy for the elected officials to take an action to address the problem. Tobacco is a classic case, I think. When they do not, as you point out, something is going to happen. Something is going to happen, and several things may happen, and he was making the point, there may be several bites out of the apple where one would have done the job if the Parliament had acted. But thanks so much for your comments, and I think we've got ample work to do. We want to do 3 more volumes, but whether you want that many 40-watt bulbs is thanks a lot.
Thank you, Bruce. A few quick things. One is on the center's website, which is on the case website, which will email to all of you. We've been collecting links to websites that follow this sort of thing, academic papers on these subjects. We'll be posting written versions of the commentary that we got from John, Kerry, and Bill. So if you or your students or others are interested in investigating these topics, we're hoping that site will be a kind of a handy place for people to start their research and start their exploration. Related to that, as I mentioned at the beginning, we think that this sort of format or something like this format is a useful thing to do. If you have feedback on subjects that we might want to try and do these sorts of roundtables on, ways to tweak the format, please let me know. We kind of like this format, but we don't think we've necessarily got the perfect one, and so if there are suggestions you have to make, I would certainly appreciate hearing that.